Welcome to Employment Termination and Disability Coverage, a guide for attorneys. My name is Liza Goldenberg, and I'm a member with the BHBA, and I am delighted to introduce today's speaker, Stacy Monahan Tucker. Stacy is the founding partner of Monahan Tucker Law, where she represents insureds in complex disability, life, long-term care, and catastrophic property insurance disputes. With a career spanning more than 2 decades, she is a seasoned trial attorney recognized for her expertise in ERISA and insurance bad faith litigation at the most sophisticated levels. She is also a trusted advocate in high-value claims involving significant financial and personal stakes for her clients. And without further ado, let's get started.
Hi, I'm Stacy. And it's no secret that there have been an enormous amount of layoffs throughout the United States over the past 6 months. That is the impetus for this topic. I've seen a number of questions, both from potential clients and from people working in human resources, about how these layoffs affect employees. So we're going to walk through that a little bit. If we can go to the first slide. The first question is, what are the disability benefits that people get through their employment, and how do they work? Many employers, especially large employers, offer them as part of a package of benefits. People generally focus on their health insurance and don't look at the other benefits until they need them. So we're going to briefly walk through how disability benefits work when you get them through your employment. Most of the time, disability benefits obtained through work are governed by the Employee Retirement Income Security Act of 1984, which is known as ERISA. That covers probably 90% of the employers in the United States. Benefits are not governed by ERISA if the employer is a government agency, and that includes local government, state government, or federal government. So we're talking about schools, police, fire department, state-owned utilities. Interestingly, if teachers don't get their benefits directly from the actual state, but get it from a union that represents them, or police or fire get them from unions, sometimes that can be subject to ERISA. So interesting aside there, it takes some analysis. Also, if the employer is a religious organization, it's not subject to ERISA. That doesn't just include churches and synagogues and such like, it includes businesses owned by them. In our economy, that most usually occurs with hospitals and health systems. So if you work for a hospital or health system that's owned by the church or affiliated with the church, it is possible that your benefits are not subject to ERISA. The third situation is if the employer self-funds the benefits. Most of the time, employers obtain and provide benefits by contracting with an insurance company. They get a master group policy with an insurance company, and that insurance company accepts premiums from all of the employees, sometimes paid by the employees directly, sometimes paid by the employer directly, sometimes a mix, to provide coverage. If the employer decides not to work with an outside insurance company, but to fund the benefits themselves, those are not subject to ERISA. Also, especially with higher salaried senior executives, employers can offer individual disability policies that those employees can choose as well. Depending how those individual disability policies are offered, they are usually not subject to ERISA, but it depends on the facts. So a lot of this, as you can hear, is subject to the usual lawyer response. It depends. But for the most part, and for the purposes of this discussion today, we're going to be talking largely about ERISA, because most of the benefits that employers are managing and employees are receiving, they receive subject to ERISA. Let's go on to the next slide. So I just explained that they may or may not be subject to ERISA, but the obvious question is, why does that matter? Why does anyone care if it's subject to ERISA or not? It matters because ERISA was originally designed to make it easy for employers to offer benefits so that they wouldn't be dealing with massive amounts of lawsuits. They wouldn't be dealing with massive amounts of pushback from employees about not doing it correctly. So ERISA offers a very clear structure for doing this. And if it gets to litigation, the litigation rules around ERISA are very different than traditional litigation. The intent of that was to encourage employers to offer benefits, which employers don't have to offer, right? It's a benefit they offer. And the government realized that more and more employees were relying on work for their welfare related benefits, and they wanted to encourage employers to offer these. So ERISA is part of the way in which the government encourages employers to offer benefits with the intent of making it easy for employers to do so and limiting their exposure. In reality, over the past 50 plus years, employers usually aren't offering the benefits themselves. It's an insurance company that's offering them, and the employer contracts with the insurance company. Over the course of time, courts have agreed that the insurance company is usually the proper defendant in any lawsuit. That means that for practical purposes, the insurance companies are the ones benefiting from the limited exposure and streamlined litigation approach related to ERISA. The employers don't get sued related to this, or at least not usually. Usually these days, it's the insurance company that is sued, and the insurance company benefits tremendously from not having to go through the traditional litigation process and not having to pay all the costs associated with the traditional litigation process and the exposure to additional damages that can occur in traditional litigation. So it has resulted in insurance companies having a strong incentive to deny claims because most people don't want to reach out and obtain an attorney, and most people don't want to bring suit. So the suits related to these denials, insurance companies have come to accept them as part of the cost of doing business. And here's some of the differences between ERISA and non-ERISA and why it matters for how employees are getting these benefits in the first place. There are very strict regulations related to time limits and requirements that affect both the insured and the insurer. ERISA, most of the time, preempts state contract law, and there are detailed analyses that go into that. And this is not a seminar on how ERISA works, so we're not going to delve into that. But most of the time, it preempts state contract law. There's no exposure to punitive damages or future benefits if you are ordered by a court to pay benefits, if you're an insurance company. The most a court can require is that the insurance company pay back benefits and that they reinstate or instate benefits for so long as the insured remains disabled, according to the insurance company. Most of the time under ERISA, there's no discovery. The cases are limited to the claim file, or what's known as the administrative record, which is the documents that the insurance company relied on in making its determination. There are no witnesses. There's also no jury. It's a bench trial decided by a judge with no witnesses, completely reliant on the information in the administrative record. So if it's not in the administrative record, the judge is not supposed to look at it. And as we discussed, there's an incentive for insurers to deny claims because there's no penalty for them for doing this. The worst that can happen is that they'll have to pay the benefits that they would have paid anyway. Because ERISA is federal law, the lawsuits must be brought in federal court. It's not based on diversity jurisdiction, it's based on federal law jurisdiction. If the insurance is determined to be non-ERISA, then it's subject to the state contract and tort law of the state in which the lawsuit is brought. It's a traditional litigation. It has discovery and discovery disputes. It has witnesses, it has experts, and it has a jury. There is exposure to punitive damages and bad faith damages. And depending on the state you're in, if your state allows it, judges can order the payment of future benefits as part of punitive damages as a deterrent to insurance companies. Go ahead and pull down the next slide. Now, under ERISA, just like non-ERISA, the contract language generally controls. But if the contract does not align with ERISA, then ERISA would control. Because of this, generally speaking, insurance companies are well aware of this. ERISA is national law. Most contracts are going to align with ERISA. Under ERISA, an insured has to appeal within 180 days of a denial of their claim. They can't bring suit without first appealing. If you try to avoid the appeal and you wait more than 6 months and you bring suit without appealing, you forfeit your right to bring suit. You have to exhaust your administrative remedies, which is appealing. So it's very important for anyone who is bringing suit or advising somebody about their claim that's been denied, they have to appeal within 6 months. An insurance company has to decide a claim within 45 days of receipt of the claim. They are allowed to take extensions, but the insurance company has to notify the insured in writing, explain the reason for the extension, and when they anticipate making a decision. If the claim's denied, the insurer has 45 days to decide an appeal once it's submitted. But they can take an additional 45 days in what ERISA describes as unusual circumstances. If the insurer misses their deadline, the claim is deemed denied under ERISA, and the insured can either appeal if the initial deadline for making a claim decision was missed, or they can bring suit if the appeal deadline was missed by the insurance company. The insurance company is required to provide a copy of the claim file after a denial, and if an appeal is upheld. And that has to include any internal policies and procedures the insurance company relied on. The insurer and the employer are required under ERISA to provide copies of all plan-related documents within 30 days of a request. The employer, not the insurance company, only the employer, is subject to fines of up to $110 a day if it fails to comply. It's important to note that this regulation applies to both current and former employees who request this documentation. I've had a number of situations where clients have informed me that their employer has refused to provide this documentation because they're no longer employed there. That is irrelevant under ERISA. If they are potentially covered by the insurance, which we'll talk about in this presentation, then they are entitled to this documentation. So you have to provide it upon request. Meanwhile, if this is a non-ERISA claim, then the contract language controls subject to state laws such as the notice prejudice doctrine, which we're going to talk about coming up. And let's go to the next slide. So I think this is the same slide. Thanks. We talked a little bit about ERISA litigation. The appropriate defendants, according to ERISA, are the insurance company and or the plan, which is a separate legal entity under ERISA. The plan is owned by the employer, and the employer usually handles the litigation if it's brought against the plan, but the plan is a separate legal entity. Most of the time these days, the insurer is the one who is the defendant. Most group disability contracts grant the insurance company what's called discretion to decide claims. This allows courts, or requires courts, I should say, to review the claims under what's called the abuse of discretion standard. That means that the judge has to decide not if the insurer was right or wrong in denying the claim, but if it was manifestly unreasonable. That means they have to give weight to the insurance company's discretion. So if there's a reasonable basis that the insurer could have decided to deny a claim, if it could have gone either way, the court under this standard is required to support the insurer's discretion in making that call. In several states around the country, especially in the Ninth Circuit, laws have been passed banning these discretionary clauses. Without the discretionary language, courts apply the de novo standard of review, and that means that the judge reads the claim file and decides based on that administrative record whether the benefits should be approved or denied. The opinion of the insurance company is irrelevant. It's just based on the facts in the file. In the Ninth Circuit, California passed the California Insurance Code 10110.6, which bans discretionary clauses. Oregon has it, Washington, Montana, and Hawaii and Alaska have it, but they haven't issued official rules or code changes. They've done it based on their insurance commissioner's interpretation of existing rules, that the language is confusing and not straightforward, and that it violates the intent of insurance policies. Idaho also has an insurance rule that covers this. For obvious reasons, de novo review is better for plaintiffs instead of abuse of discretion, where abuse of discretion gives additional weight to the insurance company's weighing of the evidence compared to the judge's weighing of the evidence. So it's a benefit to insureds, to employees, to plaintiffs to have their claim reviewed under de novo review. And let's go to the next slide. And one of the first questions that I hear from people who call me up with concerns about finding out that they're being terminated while they're on disability. Can they be terminated while they're on an active disability claim? The simple answer is yes. Yes, you can be terminated while you're on a disability claim. I'm not an employment attorney, so I'm going to cover the basics of this, but if you have concerns that you are being singled out or that a potential client is being singled out based solely on their disability, you will want to talk with an employment attorney about that. In general, you can't single out an employee for termination solely because they filed for disability. First, if you're an employer and you're subject to the Family and Medical Leave Act, then you cannot terminate them during the 12 weeks of protection provided by that act. If you are not subject to it, then that employee doesn't have protection under it, but you still want to be very careful, just as a practical matter, that you're not immediately terminating somebody because they are disabled. The American with Disabilities Act protects employees who can work with reasonable accommodations. So as an employer, you have to consider reasonable accommodations. They're fact-based. They're determined by the individual employer and the accommodations requested by the employee. For some employees, asking to work from home remotely is a completely reasonable accommodation, depending on the type of work they do. For others, it's completely impossible. It depends on the facts related to the job, and that needs to be considered by any employer that is dealing with an employee who becomes disabled. Let's go to the next slide. So if you are an employee or an employer and you issue notice of impending layoff or impending termination, that employee, all the employees who receive those, are still covered by their group benefits until their last day of work. So they can make a disability claim after receiving notice of termination. Obviously, that disability claim can't be ginned up out of thin air. The employee is going to have to demonstrate that they are disabled under the terms of the policy. They'll need physician support. They'll need medical records. But it is completely possible and appropriate under the law for employees to bring disability claims under their policies right up to, and we'll discuss, even after they are terminated, so long as that disability began prior to termination while they were employed by the employer and covered by the policy. If an employee is on disability and a new disability arises, the insurance company is responsible for that new disability as well. Kind of the eggshell plaintiff concept. You are responsible for what you get. If you have an insured who is disabled, let's say based on mental health, and then they're hit by a car, the insurance company is responsible for continuing benefits based on that new disability as well. And once an insured is determined to no longer be disabled by the insurer, if the insured has left employment, then they are no longer covered by their benefits. They can't then make a new claim for a different, if they're determined to be not disabled, they appeal, the appeal's denied, they don't sue, they cannot then get hit by that car 6 months later and try to make a claim under that same insurance policy. They are not covered by it if they are no longer employed. Go ahead and go to the next slide, please. When employees are terminated or large layoffs occur, severance agreements are usually involved. The severance agreement is going to affect how the employee can access these benefits. The general, very broad language that's included in most severance agreements includes language about waiving their rights under all sorts of potential scenarios. ERISA is generally thrown in there as part of a laundry list. And those severance agreements waive the employee's ability to bring suit under ERISA. Depending on how it's worded, it may or may not clearly include the employer's insurance companies and insurers and agents as well. If it doesn't, then there's a lot more question about whether or not an employee's waived their rights under ERISA. But an employee who is out on disability or who is in the process of making a claim who asks to have that carved out, that's a reasonable request, because if they waive their right under ERISA, then they're not able to enforce their coverage under the existing policy. I've actually had a case on this. Before I represented plaintiffs, I represented insurance companies for many years. And we had a case, which we're going to talk about, Perez Jones versus Liberty Life Assurance Company, back in 2016, where the insured had been on disability for a few years, and she signed a severance agreement in the middle of her disability. She'd been out for a couple of years. There was a merger. She got laid off. And she wanted that payout, but she also wanted to stay on her benefits. And let's go to the next slide, because the next slide talks about this a bit more. So Perez Jones was a banker, and her bank was bought in a couple of different mergers, ending up being owned by Wells Fargo. And in 2008, I believe, that merger occurred, and she was out on disability at the time. And she'd been out for about 2 years. And her severance that was offered to her was pretty significant. It was over a year of salary. And she wanted that severance payment. However, Wells Fargo set it up so that she could only receive the severance payment once she came back from disability leave. She could be on leave as long as she needed, but she wanted to get that money now. In order to get the money now, she had to come back off of leave. But coming back off leave meant she was no longer disabled. She called the insurance company several times, first told her that there might be a severance agreement and wanted to know what that would look like. Insurance company said, it depends on what the agreement says. Send us a copy and we'll look at it and tell you how it would affect your benefits. She did not do that. Instead, she called back and said, "It looks like I'm not going to take the severance agreement. It looks like I might be able to come back to work. Tell me what a successive disability claim looks like." Under a successive claim, you can try to go back to work. And if you're not able to because your health doesn't allow it, you can go back out on claim again based on the original claim. It's viewed as a continuation of the original claim. So Liberty explained that to Perez Jones, and she just told Wells Fargo that she was coming back to work. Her doctor released her to come back to work. She came back for one day to sign the severance agreement and get the benefits. She did not tell Liberty Life she signed a severance agreement. And as soon as the check cleared, she made a successive disability claim, told Liberty she tried to go back to work. It didn't work out. She couldn't do it. And she went back on disability for 2 more years. Liberty eventually terminated her benefits, and she brought suit saying that her benefits should have continued. During the suit, Liberty learned for the first time about the severance agreement and argued that she was not able to seek these benefits because she waived them under ERISA. The court ended up having an entire mini trial in the ERISA case with witnesses and discovery to determine whether or not she had knowingly and willfully signed away her ERISA rights. The court considered the plaintiff's education and business sophistication, the roles of the employer and the employee in negotiating the agreement, how clear the agreement was about the waiver, how much time the plaintiff had to review it, whether the plaintiff had the ability to consult counsel, and how much money she was paid for the waiver. The court ultimately decided that she had knowingly and intentionally waived her rights, and therefore she could not bring suit, and she lost. Her counsel appealed, and the Ninth Circuit agreed, but they looked at it a little differently. They said you never needed to get to the question of the severance agreement in this situation, because when Perez Jones came back to work and accepted her severance and quit, she no longer had coverage under the policy and could not make a recurring disability claim. She wasn't covered anymore. And so therefore, the severance agreement was irrelevant. Once she quit and wasn't working, she could not then claim disability that started after she stopped working. Let's go on to the next slide. So, can an employee make a disability claim after learning of your impending termination? Yes. Courts have been very clear about this. Insurance companies like to argue that they're obviously not disabled because they've been working. How are you disabled if you're also working? Courts have repeatedly held that there's no logical incompatibility between working full-time and being disabled. Many people, because of economic realities, force themselves to work even though they meet the definition of disability under the governing policy. And the fact that the plaintiff was physically at work doesn't mean that the plaintiff couldn't also be disabled on that date or even earlier. There's no bright line rule that an employee must claim disability before being terminated to receive long-term benefits. So yes, an employee can find out that they're being terminated and then make a disability claim. Employers are often very surprised to hear this, but it's extremely clear under the law. They are allowed to do this. They, of course, have to demonstrate that they have evidence of this disability. They have physician support of the disability. But oftentimes, one of the reasons people are getting fired or getting included in a layoff is that they weren't working up to their employer's expectations. Oftentimes, that's because their disability didn't enable them to do so. Let's go on to the next slide. Next question. Can a former employee make a retroactive claim for benefits under ERISA or a non-ERISA policy after leaving the company? And the answer, again, is yes. There are many cases out there that have held this, the most recent of which just came out in May, Dharmasena versus Metropolitan Life. In this case, the plaintiff had muscular dystrophy and kidney disease. He worked despite these issues using a walker and orthotic devices. He loved his job. He wanted to do his job. He put himself in enormous discomfort to do his job. He was included in a layoff and was terminated. After the layoff and after being terminated, he made a claim for disability benefits, stating that he had been disabled while he was employed. The insurer denied it, saying that he obviously had been able to work, as demonstrated by the fact that he had been working and that he worked right up until the date of his termination. The court, meanwhile, disagreed. The court reviewed his medical records and noted that, yes, he was terminated on February 4th and so stopped working, but he could be disabled while still working. The court held that the last day of work and the date of disability are distinct analyses. And since the insurance company didn't look at it that way, the retroactive claim was permitted, so long as the record evidence supports disability before the last day of work. So that's the issue that has to be reviewed here. Did the disability begin before the last day of employment? Not did you bring the claim by the last day of the employment? Did the disability begin before the last day of employment? That's what the court looks at, and that's what anybody making a claim needs to look at. And human resources departments who are asked questions about this by their employees need to understand this as well. Yes, an employee can call back after being terminated, after no longer working there, and ask for the information about how to make a claim. And yes, the Human Resources Department has to provide that. If the Human Resources Department refuses to provide it, they can be held responsible for that $110 a day fine for the employer not providing the plan documents and plan information. Let's go on to the next slide. So most insurance policies include a time limit by which you have to promptly make a claim. They also include requirements saying that it has to be a claim or litigation has to be brought within X number of years after knowing of the basis for the claim. Insurance companies point to these as a basis for the claim not being able to be brought retroactively, saying that it's too late, you don't have coverage. How that's going to be determined is a state-by-state question. Many states, including in the Ninth Circuit, have adopted what's called the notice prejudice doctrine. It's a state law doctrine that holds that an insurer cannot refuse a late claim just because it's late, unless the insurer can demonstrate actual and substantial prejudice because of the late submission. All the states in the Ninth Circuit except Idaho have adopted this doctrine. That means that all of the states in the Ninth Circuit except Idaho require their insurance companies to accept and review a late claim. Now, the insurance company can look at this and say, we are actually and substantially prejudiced because we don't have the opportunity to examine you in real time at the time you claim your disability began. We don't know what your physical capability actually was 2 or 3 years ago when you claimed to have become disabled. We've been prejudiced by having that ability taken away from us. Courts will look at the actual information in the record in determining whether or not they think that's a reasonable argument for the insurer. It's going to be fact-based depending on the disability and the documentation of it. But that is the kind of actual and substantial prejudice that the insurance company can argue when dealing with these notice prejudice claims. Notice prejudice, by the way, not preempted by ERISA. The US Supreme Court confirmed that back in 1999. So it does apply to ERISA as well as non-ERISA claims. And let's go to the next slide. So when do former employees bring late disability claims? It can happen years after leaving a company. Generally speaking, the typical situation is when an employee is having a hard time getting a diagnosis. When something's wrong, they've been treating for their symptoms for years often, trying to get somebody to figure out what's wrong with them, why they're unwell, why they're exhausted. Oftentimes, it can take years to get the correct diagnosis. Insureds and employees can bring claim for disability without having a diagnosis. Disability is based in the symptoms, not the diagnosis, but most people don't realize this. And most insurance companies push back quite a bit if there's no actual diagnosis, saying that if you don't have a diagnosis, how do you show there's something really wrong with you? So it's a bit of a catch-22 for these employees or insureds who are having symptoms. Nobody's been able to tell them what's wrong with them or how to treat it. One of the requirements under most disability insurance policies is regular treatment by a physician, being under the ongoing regular treatment of a physician. That can be hard if your physicians don't know what's wrong with you. You tend to bounce back and forth around with different doctors, having different reviews, different opinions, different recommended treatments. So oftentimes, an employee may not realize that they're disabled until years after their symptoms begin. They may not understand that they have a claim. And courts have been very clear. The fact that a diagnosis is not made contemporaneously within the time that the claimant's insured doesn't undercut the viability of a later diagnosis based on medically acceptable techniques. The diagnosis can be properly made several years subsequent to the onset of disability. And in those situations, an insured can indeed bring a late claim, and the insurance company has to review it. The employer has to provide the documents allowing them to make the claim. They have to provide the plan information so that the former employee has the correct information. There is a lot of case law out there confirming this, and it's important to understand that this is where you have to be. You're opening yourself up to litigation as an employer if you refuse to do this, and you're opening yourself up to litigation as an insurance company if you refuse to review these claims. Most of the litigation around these stems from situations where the employer or the insurer simply refused to consider the claim, said, nope, it's too late, we're not going to look at it. They did not understand the requirements, and they have now been spelled out repeatedly in case law that, yes, you have to do this. Go ahead and move on to the next slide. So we've talked about the situations in which an employee can make a claim. What does that employer insured need to show, regardless of how long it's been? Or how recent it's been. You have to demonstrate that you were experiencing your disabling symptoms and prior to your last day of work. You need physician support of that disability. Physicians that are treating you saying that you became disabled on or prior to your last day of work. And disability is a contract term. It's determined by the language in the insurance policy. Usually, that language says something about the inability to perform the material duties of the insured's own occupation or regular occupation for at least the first 2 years of coverage. If it's short-term disability, oftentimes it's their own job that they have to show that they're disabled from. That means that whatever the requirements of that particular job are, if the employee can't perform the material duties, then they can't do that job. So if that one job requires the employee to physically be in the office, and for whatever reason, based on their disability, they can't, then the fact that they could potentially work from home doesn't matter. They're disabled from that job. Occupation opens it up a little bit more, and the insurance companies push hard on this, arguing that the occupation as performed generally in society isn't limited to what a particular employer requires. And they try to broaden that as much as possible, saying that just because you can't work for the requirements of this company doesn't mean you couldn't work doing the same occupation for different requirements imposed by a different company. Judges tend to be a little skeptical of this argument, and if the insurer refuses to review the actual job description of the actual employer, it usually goes poorly for them. This is another reason it's important for employers to have job descriptions for their employees and to provide them to the employee upon request, because the employee needs to rely on that in making any claim for disability. They have to be able to point to this. Part of what you need to be able to show when you're disabled, testing. Like we said, physician support, medical records. A lot of times, depending on the policy, there may be a 2-year limitation in place for self-reported symptoms. So if the disability is based primarily in what's considered self-reported symptoms like fatigue or pain, then headaches are an excellent example. People disabled by migraines. Insurance companies argue that that's subject to the 2-year limitation for self-reported symptoms. Whether or not that actually is correct, courts go back and forth on, arguing that many symptoms can be objectively determined with testing. And so pain, for example, can be objectively determined by testing. It really depends on the type of disability that the insured has claimed and the type of testing available for it. Let's go on to the next slide. So if you are an insured and you've made your claim, and maybe benefits were paid for a while and denied, or maybe they were denied from the get-go, and you appeal, and your appeal is denied, you then, the next step, and the only step available to you, is bringing suit. So the question is, what does that look like? Under ERISA, venue technically is appropriate anywhere in the country. However, if the insurance company doesn't want to be sued in a particular area, the insurance company can bring a motion to change venue, arguing that the venue is inconvenient. And so that typically happens when the insurance company doesn't want to be sued in what they view as a more beneficial to the plaintiff jurisdiction. So let's say that you are an employee in Massachusetts, and you file suit, and you want to file suit in California, but your employer is based in Massachusetts, the insurance company is based in North Carolina, and you live in Massachusetts. You are likely going to have a hard time bringing suit in California because the insurance company is going to make a motion to change venue, noting that there are no ties to California, and it's inconvenient, and it doesn't represent justice because California has no vested interest in the claim. But what if you work in Massachusetts and you work for Microsoft in Massachusetts, and Microsoft is headquartered in Washington, headquartered in Redmond outside of Seattle? Then can you bring suit in the Ninth Circuit? Can't bring suit in California, but you can bring suit in Washington and file in Washington federal court. And courts have repeatedly held that there's no legitimate basis to overturn that because the plan is based there, and the plan is part of the coverage. So venue under ERISA, most courts have held, can be proper where the insured lives, where the insurer is headquartered or incorporated, or where the plan is administered. The plan is almost always administered in the employer's headquarters. It's where human resources is. That's typically considered where the plan is administered, where decisions about the plan are made. So these large layoffs happening by West Coast firms, including Microsoft and Meta and Google and Amazon, Salesforce, Starbucks, all of these that are happening, those employees being laid off all over the country, all of them can file suit in the Ninth Circuit because the disability plans are administered by the employers at their headquarters in the Ninth Circuit. And And let's go on to the next slide. What are the benefits to these employees all over the country for the employees to be able to bring suit in the Ninth Circuit instead of the states in which they live? As we discussed earlier, all of these states, for the most part, have banned discretionary clauses. That means that their claims are going to be reviewed under de novo review. A judge is going to read the file, and the judge is going to decide if the benefits should have been paid or if the insurer got it wrong. The judge doesn't have to give any deference to the insurer's decision. The next obvious question, how do choice of law provisions apply here? Many insurance policies have a choice of law provision in them. That choice of law provision is going to control in terms of what law is going to be applied. The Ninth Circuit just declined to decide, just last month, whether or not a choice of law provision overrides the state discretionary ban for residents in California. So if you have a California resident who's employed by an employer in Illinois and they work in California, does the state discretionary ban apply to them if that policy has an Illinois choice of law provision? Ninth Circuit has just avoided the question. So it's still an open question. What if there is a forum selection clause? A forum selection clause is going to control. So everything we've just been talking about the ability to file where the employer is headquartered, depends on whether or not there's a forum selection clause. Most of these policies do not contain a forum selection clause, but if they do, that is going to control. The language in the policy, unless it's preempted by ERISA, is going to control. Similarly, the notice prejudice doctrine we talked about, that's going to enable all of these employees nationwide to bring late claims in these Western states that have adopted the notice prejudice doctrine, regardless of whether or not the state that they live in has adopted it. Plenty of states have not adopted it and do not allow late claims. However, these employees can avoid that if they live in one of those states by bringing suit where their employer is, if that employer is in a state that has the notice prejudice doctrine. So it's important to understand that this is what we are dealing with as lawyers, as human resources professionals, as employers, as insurance companies. Yes, these people are allowed to bring late claims. They are allowed to bring claims after they find out that they've been terminated, but before they leave. They can bring a claim after they've been terminated and after they leave. It is one of the benefits provided to them by their employment, and so long as they can demonstrate that they were entitled to use that benefit at any time up to the last day of their employment, they are allowed to access it. And let's go to the next slide, which I think is the question and answer slide. I am happy to answer questions about this, but I can also dive in a little bit more into the question of venue and how all of this works to answer anything else. Let's see. I do see a question. It's about unemployment. I'm not an unemployment attorney. So my understanding is the ability to file for unemployment is going to be based on the state law for that state, but it's not related to disability. I will say that if you're applying for unemployment, you usually cannot be on disability, because when you're filing for unemployment, you have to continuously confirm that you are actively seeking work. And if you're on disability, you're taking the position that you cannot work. So the two are in conflict. So usually an employee has to determine if they're going to go for unemployment or if they're going to go for disability. They can't do both. don't think there are any open questions right now, so I'm just going to talk a little bit more about some of the case law on these issues. As I noted, the Supreme Court has determined that yes, you can bring these late claims. That's not limited to disability insurance, by the way. Notice prejudice applies to all types of insurance. It's particularly interesting for disability because you get your disability through your employment, and you may have left the employment years prior, but you can still make that claim. And for venue, there's lots of discussion about choosing venue and making strategic decisions about where to bring claims. The Ninth Circuit is known as being a more plaintiff-friendly venue. Almost not every single court, but most of the courts in the Ninth Circuit are known for being fairly plaintiff-friendly. So if you are looking to bring suit for an insured, there can be tactical advantages to finding a basis to doing so in the Ninth Circuit, depending on where the employer of the insured is located. And human resource employees need to understand these issues as well, so that they understand when their prior employees are asking for information, what they have to provide. And that, yes, not just the insurance company, although usually the insurance company is the one sued these days, the plan can be sued by someone anywhere in the country as well. And the plan can be sued in the state, in the court where the plan is located. So the employer has exposure, the insurance company has exposure. It should be completed there. And I see comments about the proliferation of third-party employers. That is a really good question. The plan can have a third-party administrator, but the third-party administrator is not the plan itself. It's a third party. So the plan can hire somebody, but that's not going to change where the plan is located. That third-party administrator, they may be, let's say they're in North Dakota, but the plan itself is still located at the headquarters of the employer. I've seen insurance companies try to make this argument, and usually courts have agreed that the plan is administered where the headquarters is, because there's more to administering the plan than what the third-party administrator is doing, right? Somebody had to hire that third-party administrator. Somebody's paying that third-party administrator. Third-party administrator usually cannot make changes to the plan. It's the employer who can make changes to the plan. All of that is part of the administration of the plan, and that's still happening where the employer is located. So no, you're not stuck. If TriNet is in North Dakota and the employer are in California, you're not stuck with what TriNet dictates. If the employer is an employee of TriNet, then yes. Then if their insurance is through TriNet and TriNet is the plan administrator for its own insurance that it's offering, then yes, the employer is TriNet. So Microsoft, for example, who uses lots of different contractors, you may be doing all of your work for Microsoft, but you're still employed by the contractor that hired you. You're not an employee of Microsoft. So in that situation, yes, if you work for TriNet, then TriNet is where wherever TriNet's managing that plan is where the employer would be. However, if you live in California, then you can still bring suit in California, because that's one of the places where venue is permitted. If they have a forum selection clause or a choice of law clause that is unrelated to California and it's in the plan, then that's going to control. So if the insurance policy dictates that either the forum selection has to be in North Dakota or the choice of law needs to be in North Dakota, then that would apply. Choice of law, given that it's ERISA, you should still be able to file in California and have Ninth Circuit California law apply. ERISA technically is federal law, which means it's national. The reality of the fact that courts around the country tend to interpret it differently wouldn't be determined by a choice of law selection. So you'd really want the forum to be in California in this situation. If you're working for an employer in North Dakota, but you live in California, you could bring suit in California, still have all the benefits related to the Ninth Circuit, and that would hopefully resolve the issue for that. Now, if you worked in Texas and the employer was in North Dakota, you'd have a hard time making an argument that you should be able to file in the Ninth Circuit. Any other questions that I can answer? We are almost out of time, but we do still have a few more minutes left. These issues come up more often than you would think. I'd say about half of the cases that I have involve people who were trying to push through with working because either they loved their job or they needed their job, and only make claims when they realize that they're losing their job regardless. So this is something that comes up a fair amount, and understanding how it works, whether it's for your employees, if you are working for a large employer, if you are a wealth management attorney and you find out that one of your clients is getting terminated and they don't know what to do, depending on their health situation, this is an option for them. Obviously, they'd rather be working, but 60% of your salary can be better than nothing while you're focused on your health. ADHD can be a disability. Sorry, answering a question here. I see a new question just popped up. It depends on the severity of the symptoms and the doctor's support. Executive function and cognitive disabilities are definitely bases for disability. In order to obtain that, you would likely need some kind of neuropsychological testing that would support the inability to do the requirements of that job or occupation. So it can be, in reality, it would be if ADHD were the only issue, it would be difficult to make a claim for that because presumably the ADHD had existed throughout the course of employment, and the insured had been able to do their job the entire time. For mental health, oftentimes depression and anxiety will spike when somebody finds out that they're being terminated. That can be a basis for a disability claim, assuming physician support. Lots of people have ongoing treatment and end up for mental health, but are able to do their jobs, and then something changes. Maybe there's a death in their family. Maybe they're terminated. Something happens that causes that previously manageable disability to no longer become manageable. And those are situations where mental health can change and start to fall under the umbrella of disability when previously the insured was able to work. And we are just about out of time, but I'm happy to answer any more questions if there are any. Let's see. Just saw another question. Can an employee with a disability accept a new job in the company and later file for long-term disability when terminated? Absolutely. If you're still employed, then you are still covered. If you're still employed by that same company, then yes, you're covered. And if you're disabled and you have medical support to demonstrate that disability and your doctors support that disability, then yes, you could absolutely file a claim later down the road. You can file a claim. You can be out on disability for a period of time. You can come back to work. You can work for a while. If your symptoms increase again, you can go back out on disability. The benefit is there to protect you based on issues with your health. And health, as unfortunately we all know, is never something that you can 100% rely on. people can get better, they can get worse. Most people want to work. Most people like their jobs and like the security of a job and don't want to be on disability. So when they're applying for disability, usually it's because they need it. And it's important, especially for human resources people, to remember the insurance companies deny most claims. That does not mean that your employee is not disabled. Something to keep in mind, we hear employers often treat employees differently after a claim is denied because they think that the employee must be making it up. Most insurance claims are denied. That is not because the insured is not disabled. It's because it's a business model for the insurance company, which is important to know. Another follow-up question, if the disability doesn't affect the new position, could you still file for long-term disability? Likely not, because the definition of disability is going to be that based on the ability to perform the duties of that job. If you are able to perform the duties of a new job, then you're not disabled from that new job. But it would depend on the language in the policy. So that's really what's going to control. It's a contract like anything else. The language in the contract is what controls. Any other questions? Otherwise, I think we are at time.
Alrighty, it doesn't look like we have any more questions. This concludes today's presentation. Once again, I'd like to thank you, Stacy, for an excellent program. And I'd also love to thank our audience for attending with us today. Have a great afternoon, everybody.
Thank you.